Okay, so hi everyone. Um, my name is Danu Maru. I'm an immigration lawyer, and today I have with me Nupa Patel.
Hi.
Nupa, would you like to introduce yourself?
Yes, my name is Nirba Patel. I'm an attorney at the firm of Boland, Robinson and Ellis in Decatur, Illinois.
Right. And Nupa, I know we had intentioned to make this a live video for your audience as well, and unfortunately, these technical things are not my strong point, and so we're, hoping that we can compensate with this recording.
Yep, we failed at live stream, but this should work. So hopefully we get some information out to our friends and supporters, and give them some information on immigration law and criminal cases as well.
Yeah, so this should still be a very informative and interesting conversation because immigration law and criminal law have this really kind of interesting relationship, wouldn't you say?
I agree. Oftentimes, the main question I get from clients that are not U.S. citizens is, "What's going to happen to me? What's going to happen to my status in the country?" And I always have to tell them, I do not know." Um, a lot of clients think that because I'm an attorney, I have the answer to everything, which is nice to, hear, but we don't know everything, and it's impossible to become an expert in every field of law. Now, me personally, I have never practiced immigration law in my life, so I will always advise people that there may be consequences if they take a specific type of plea deal. What those consequences are, I cannot tell them because
Mhm.
it would be unethical for me to do so, since I am not an immigration law expert by any means. So I end up just warning my clients that this could impact their status in the country, and it is their responsibility to talk to an immigration attorney and consult with one and get information from an immigration lawyer as to how a potential plea deal would affect their status. And I am usually more than happy to give them referrals if they don't know who to contact. But that's usually the issues that come up in my cases is people have lots of questions, and I just simply don't have the answers as to how our criminal case will affect their status in the country.
Right. And I think it's also imperative for people to understand that structurally, immigration law is a federal area of law. And there's really not much control that states individually have over the overarching immigration law. On the other hand, the area where you work, Rupa, in criminal defense, I'm imagining you work very often with state laws.
Yes, I work entirely with state law. I do not handle any federal criminal cases at all. And I would assume that any federal defense attorney would tell their clients the same thing, that unless they have actual knowledge and experience with immigration law, they could not tell their clients what the possible outcome would be for their status. And then, of course, my clients that are not US citizens, some of them have status here legally. They have a visa. Some may have green cards, and then some are undocumented. So
Right.
I, it's immigration law is very complex. So I always encourage them to talk to a professional in that field about their case. And then, of course, I'm happy to talk to immigration lawyers like yourself about the plea deal, explain to you what the plea deal is and what that entails.
Right. So, Nirpa, can you explain to us what within, and I know you work in Illinois, so you're most familiar with the laws of Illinois, right?
Yes.
Can you explain to us, generally in Illinois, what are the different possible outcomes that a person can have? Say, suppose, person is charged with taking something that doesn't belong to them from from a store.
Yeah. So, if so retail theft depends on if you have a prior conviction and the value of the item. So if you steal something like, I don't know, like a bottle of shampoo
Hmm.
and a bottle of vodka, total amount's $45, and it's your first time shoplifting, then that would be a misdemeanor.
Mhm.
You could face jail for up to 364 days. But on the other end of the spectrum, you could also get court supervision where you would just plead guilty and a conviction would not enter against you. On the flip side, if it's your second time with a retail theft case and you already have a conviction, or let's say you go to a Gucci store and steal a belt that's valued at $2,000, then it's going to be a felony. And at that point, the possible penalties could be um, on one end of the spectrum, you could face anywhere from 1 to 6, or possibly even 2 to 10 years in prison, depending on your criminal record and the value of what was stolen. On the other end of the spectrum, you could get probation, which would mean you wouldn't necessarily be going to jail as long as you or prison as long as you comply with certain terms.
And how, you as a lawyer, how do you work to make sure that, your clients receive the lightest possible sentence for given the amount that they have taken?
So I will talk to the prosecutor and try to negotiate a good deal. I always try to come up with what I call a mitigation packet. So if my client is is working but is struggling to make ends meet, I could provide the prosecutor proof of my client's um, employment as in the form of a paycheck. If my client is doing community service work, I could provide proof of that as well. Let's say, and sometimes it is drug related, that people are stealing because they're suffering from a drug addiction, and I have my clients voluntarily get a substance abuse evaluation and treatment. And then, with the client's permission, I'll share those records with the prosecutor to try to, try to show the prosecutor that this person is trying to be rehabilitated and better themselves. Um, Typically, just from my experience, prosecutors are fairly reasonable when it comes to theft cases, as it's not a crime of violence. I've only seen people go to prison on theft type of offenses if they're repeat offenders. And it's just, me talking to the prosecutor, sending them any proof they need to show what my client's been doing, and that usually ends up resolving the cases.
Right. So there's some like words that I heard, which to me as an immigration lawyer, doesn't really
Mhm.
become a part of our vocabulary, right? Things like, you said, conviction versus, so someone could plead guilty potentially and still not be convicted,
Yes.
right? Um, so in immigration law, it's like very, very different. Um, and retail theft is a really good example because retail theft is treated differently in immigration law than it seems to be in your world in the criminal defense law, where it's it's kind of a slap on the wrist. Like it could be a very light sentence, especially if it's a first time offense, and a smaller amount. On the other hand, the three categories of crimes that we work with, there are regular crimes, there are crimes involving moral turpitude, and then there are aggravated felonies. And retail theft actually comes under that second section called crimes involving moral turpitude. Loosely speaking, crimes involving moral turpitude are crimes that involve some level of intent to deceive, lie, commit fraud, cheat, one of those intent crimes. Um, and so, because retail theft is stealing, it also comes under a crime involving moral turpitude, which is, the fascinating. I think the history of this is pretty fascinating, and I might be wrong, but my understanding from the history is that this came about because very, very back in the day, right, when there wasn't really a lot of ways to check on what someone was saying, if it was the truth or not. And people were coming in, pilgrims were coming in, from various European countries to the United States. And they would sometimes lie about their age. They would sometimes lie about their name. They would lie about whether or not they have a criminal record. And so immigration law evolved to really heavily punish liars, cheaters, stealers, you know, and so these crimes that involve things like retail theft for someone who's not a U.S. citizen could, make them inadmissible to the United States, especially if it's a higher amount. And so when we work with, criminal defense lawyers like yourself, sometimes we work to recategorize these things as something else. Like maybe we could make it so that it's not, um, you know, a crime involving moral turpitude, or, you know, we talked about this, in some contexts where, recategorizing the crime can, reduce how it's seen. But with retail theft, luckily, there is like a one-time exception, where if it's a small crime, even if it's a crime involving moral turpitude, and if it's a small offense, but also a first-time offense, that, they can qualify for something called like a petty crime exception, but that's only for first time offenders. Two or more crimes involving moral turpitude, or CIMTs as we call them, will very, very likely render somebody as inadmissible and require like multiple waivers, or, other, measures to, gain admission to the United States, to be able to change their status, to be able to enter the US. Um, which is different from being deported, um, but, nevertheless, it's very serious, because someone who's simply traveling, someone could be a green card holder or a permanent resident, and they would simply be traveling outside of the country, and on re-entering, they're considered to be seeking admission. And so a lot of times, unsuspecting travelers find themselves, um, and their green cards in jeopardy because, of some history with CIMTs.
And I'm so happy you brought that up because I remember when I was in law school, we had a legal research class, right? And we had these like these questions, and we had to go hunting through the law library to answer these questions. And I recall having a page to fill out about immigration law. So we cracked open secondary resource materials, and I recall reading about crimes of moral turpitude. But again, this was years ago,
Yeah.
and just like um thinking about it, I would have, and I'm a, I'm an attorney too, I would
Yeah.
have assumed that moral turpitude meant something like attempt murder or aggravated battery.
Right.
So I'm
Yes,
learning too.
right. It
I had no
sounds so
idea that,
serious.
yeah, that retail theft was considered a crime of moral turpitude. Now, is is for immigration purposes, Eh, is it important to have a plea of guilty, or are arrests considered, or are arrests in and of itself used against the person?
That's really interesting. So it's a little bit more complex. Arrests are definitely looked at as a measure, as a way to screen. They cannot be used against the client on their own, because they're just allegations at that point. However, under immigration law, um, even a verbal admission of a crime is considered similar to a conviction. So someone could just verbally say, yeah, well, I was stealing. And regardless of whether they were convicted of that or not, they could be treated like someone who's committed a crime involving moral turpitude.
What about if, and I know a lot of counties have this. What if a county has a diversion program where they were arrested, they're first time offenders, and the state's attorney ends up enrolling the defendant into a program for diversion, and it includes community service work, maybe donating something and staying out of trouble, and there's never a plea of guilty or anything, and once the individual completes the program, the state's attorney dismisses the case.
So that's a really good question. So really, the plea of guilty is the deciding factor. If there is no plea of guilt, then at that point we can say that this case was dismissed, and then it should not be considered a crime involving moral turpitude. But if it's with a guilty plea, and even if it's a very light, punishment, and maybe just even a fine, even then, it's just kind of either you're guilty or you're innocent, and it's very hard to
Right.
find like an in between gray area.
Now, I have experience with juvenile delinquency cases. So I've had experience representing both adults and juveniles. Is it the same effect for juveniles if they have a juvenile delinquency case?
Um, yes. So someone could be underage and still be treated as a person who's committed a CIMT. And there, and immigration law just breaks it down into very few categories, and it's very much more black and white. I think criminal defense law has evolved, to really expand on the shades of gray, um, in between all of these different offenses and possible solutions. Um, but yeah, we don't really see much. Um, there could be some arguments in the context of, say, if I were to prepare a waiver for a CIMT, one of the factors I could list as a hardship factor or a factor to consider is, that this was very long ago and that, the person had committed a CIMT, but because so many years have passed, they've rehabilitated or something like that. But those would be factors that would be considered after an inadmissibility finding has been made.
Okay. Um, is is there any type of criminal offense where it would be just automatic? Like this is just so bad that we're not going to let you back in the country again, or that we're going to start deportation procedures.
Yeah, so there's two sets of laws that we follow. There's admissibility laws and then there's removability laws. And for admissibility, for being considered inadmissible, it's a pretty low bar. A lot of times, one or more CIMT, you're inadmissible. Um, but for removability, the bars are slightly different, and there is, and I don't know everything offhand, but there is a difference in terms of um, you know uh, the whether something would be considered removable. Drug offenses, for example, are taken very seriously in immigration law. Um, Even some states have legalized marijuana, but under immigration law, it's not legal still. So somebody could be, um, they would be driving under the influence of, say, in marijuana or something like that. But the possession of marijuana itself would also be considered a problem for someone who's not a citizen.
What are the most common? So I'll ask you first, and then I'll tell you my experience. What are the most common offenses you see in your
Yes.
profession?
Yes, we see, most commonly we see a lot of drug offenses and CIMTs. Sometimes we see solicitation. Sometimes we see DUI. Um, some kind, like, very, it's the smaller offenses that we see most often. Larger offenses or multiple offenses would be more difficult to defend because they would be considered removable offenses.
So, from my experience, I would say that I would say a majority of the offenses are misdemeanor. So, it's not very common for me to get a case involving a non-citizen that's a felony,
Mm-hmm.
but it typically is DUI or some sort of theft offense. Um, and I get the occasional domestic batteries as well.
Yeah,
For the
we do. We do
yeah,
get those as well.
for
Mm-hmm.
the felony cases, it's typically aggravated DUI, because if you have a DUI and if you do not have a valid license, then that will make it into a felony offense. Luckily, knock on wood, I haven't had repeat offenders on domestic battery, because that's another type of offense where if you have a conviction for domestic battery and you do it again a second time, then it becomes a felony. So luckily, I haven't personally had that experience. more oftentimes it's a misdemeanor, and if it is a felony, it's almost
Mhm.
always aggravated DUI without having because they didn't have a valid license.
Right, right. That makes sense. And so, um, one one thing I wanted to really talk to you about is this Supreme Court case that I'm sure you're familiar with, Padilla versus Kentucky, which has deep impact on both immigration as well as criminal defense laws. Um, how do you see that as having an impact on how you practice?
Which one? Which what's the summary of that again?
So
I
Padilla
read it.
versus
I read
yeah,
it,
yeah,
but
yeah.
I
So
cited in
Padilla
cases.
versus Kentucky, my understanding is that it is the Supreme Court decision which essentially makes it so that criminal, like in the criminal court, immigration status must be considered.
So we always give an admonishment in court.
Right.
Um, yeah. So it is something that judges will typically do in the beginning of the case,
Hmm.
like right when someone is right after someone is arrested or given a notice to appear in court. Um, when their formal charges are being read in court, the judge will let them know that if you are not a citizen of the United States, then this case can be used against you by immigration authorities, and it could result in the removal, in your removal from the country or denial of reentry. And they will reiterate that again a second time if a person pleads guilty. So they are informing defendants of possible consequences, not specifically, but just that there could be possible consequences that
Hmm.
involve the removal or denial of admission in the beginning of the case, and then also at the end of the case as well.
Right.
And the one thing I struggle with is they don't more often than not, my clients will not talk to an immigration attorney. And
Right.
it's like,
And it's very important for them too.
yeah, I've had a couple that will go and talk to an immigration lawyer, and then um, the lawyer will reach out to me to make sure that they understand exactly what's going on in our case. But it's very rare. And I I actually had a client who pled guilty, and I warned him multiple times that the plea of guilty can and will be used against you by immigration authorities.
Right.
And we tried to get him to see an immigration lawyer, and he just didn't. So
Mhm.
he ends up going to court, and then he ended up getting detained by immigration. And then of course after that, that's when his wife was like, "We're gonna go ahead and hire an immigration lawyer now." And it's like, okay, well, good luck with that. But
Yeah.
I wonder if maybe we could have prevented that if you'd hired or talked to an attorney beforehand,
Right.
and possibly we could have worked something out. I don't know, but it was just too late at that point.
Right. So, have you ever had a situation where you were able to get some kind of post conviction relief? I had a situation um, where it was someone who was a non citizen, but he had entered the U.S. when he was a toddler, like 2 years old. So everything about him seemed and sounded, and his behavior, everything was like a U.S. citizen. Um, his attorney did not realize that he was not a US citizen, nor did he ever declare that he was not a US citizen. He just didn't think it was relevant. But he was a green card holder. He was a legal, permanent resident. Um, Now, he was charged with multiple counts of mail tampering and theft and a couple other things. Like he was basically stealing packages off of porches. Um, and so he ended up getting put into removal procedure despite he was a permanent resident. So he was totally legal, but he was put into removal because of these multiple charges of, theft, which, as you know, are CIMTs, and over time they become felonies too. Um, and then nowhere in that process was he ever told that even though he's a legal permanent resident, if he's not a citizen, that somehow this is going to impact him more than it would impact a US citizen, or it could get him deported. And then in removal procedure, we had to order transcripts to see that there was no admonishment given. And then we did a motion post conviction relief to say, he was not given the proper admonishments um, for someone who's not a US citizen and how this could impact him. And we were able to get, his um, crimes convictions thrown out, without which he was treated as he was even detained permanently. So we couldn't even get him bonded out um, in the removal court. But after that, he was able to go scot free. So
So, I personally haven't had a post conviction case. Um, I I know that, oh God, I know someone I know someone did, and I was in the courtroom when it happened, and it was kind of a similar set of circumstance where there was never any sort of admonishment given that if you're not a citizen, then this could be used against you, and they ended up undoing the guilty plea,
mhm,
and starting the case all over again. I don't know what the end result with that was, but the judge did take back the individual's guilty plea.
mhm,
Um, but where I work, the judges are pretty on board about going through all of that to make sure it
right,
never happens again.
right,
And typically, typically they'll go ahead and even ask the defendant, "Are you a U.S. citizen?"
mhm,
And and go from there. There may have been one or two times in my career where the admonishment wasn't given. So I reminded the judge, Your Honor, can my client please get the proper admonishment? He or she is not a U.S. citizen. And then the judge would be happy I brought that up. They just, forgot, or whatever. But
right, sure, sure.
yeah, we're um in the district I work at, they're pretty on top of that and giving the admonishments in the beginning of the case and the end of the case.
Um, that's that's a very interesting. I'm sure this change has something to do with what the outcome would be without these admonishments and without this,
Yeah.
awareness that somehow, there is a difference in how a guilty plea, for example, would be treated for someone who's a non-citizen with regards to removability, admissibility, etc. Um, One of the other things that I wanted to kind of ask was how often, or is it common practice rather, for you to get at the end of the case a certified court disposition?
So I never get a certified copy of it unless my client requests it. So if my client needs it for any reason, we'll go ahead and order it for the client and make sure they get it. Sometimes I've heard from clients months later. Sometimes I've heard from clients 2 years later, like, "Hey, can you get me the certified copy from my criminal case, whatever it may be?" And
Mhm.
we'll just make sure that the client gets it.
So what I've found is that for immigration law, for anyone who's not a citizen, um, they need to have certified dispositions, because when they're applying for anything, like if they're applying for, say, citizenship and they're a legal permanent resident, along with their paperwork, we have to submit an original certified court disposition. If they ever travel and they want to re-enter the US, they have to provide the original certified court disposition and can't even be a copy. So I usually ask my clients to request multiple originals of these certified court dispositions
Yeah.
and just have
So
them, because sometimes those cases get expunged. And
So
then,
yeah, so no one asks me to get that right away. I've never had a single client ask me right away, but I've had some ask me later on, months down the road, years down the
mhm,
road, and then we'll supply it. And I imagine it's for that reason that you stated that they need it.
mhm, yeah. And so the other reason that I ask clients to get those too is because if their case is about to be expunged, and you can talk about what an expungement is because it's very important. But again, that's also treated very differently by immigration authorities because immigration authorities just don't even recognize expungements.
Expungements, what?
So,
Wow.
so when a case is expunged, right, there's no way to get that record afterwards, right?
Yeah, yeah. So I want to just I guess state this for whoever's watching this video. So there is a difference between expungement and sealing.
Okay,
Um
that's interesting.
yeah, so if something is expunged, then that means that the court file is destroyed, that the police reports are destroyed, that they're everything is pretty much wiped clean. It would be
Mhm,
as if you were never even arrested to begin with, and there was never a court case to begin with. Everything is gone. Sealing means to hide. So your case is exists, but it's hidden. So
mhm,
if your case is sealed, then the police still maintain records of the case, um, and the police reports and everything like that. And your case could still show up on leads if you're pulled over, or someone did a background check. But
mhm,
the circuit clerk's office that has your case, they would hide the file. So I know it sounds silly, but essentially, if someone is looking up your case on the circuit clerk's website or public database or something like that,
mhm.
your case wouldn't pop up. So the there are other little smaller rules, but the basic rule is if you have a conviction, you cannot get your case expunged.
Got it.
So if you were arrested and never charged, you can get your case expunged. If you were arrested, charged, and the state dismissed your case, you can get it expunged. If you were charged, you take your case to a trial with a judge or a jury, and you're acquitted, you can get it expunged because you don't have a conviction.
Right.
Now, the interesting thing is, and I think this would tie into what you're doing, is if you have court supervision, which I mentioned earlier, which means you plead guilty, but a conviction is not entered against you, you
Hmm.
can get an expungement for that. Now, there's special rules for DUI cases and some traffic offenses. You cannot get an expungement on a DUI supervision or some traffic type of offenses. But for a majority of court supervision cases, you can get it expunged after a certain time period. So it would be as if, you never went to court, never pled guilty.
So that's really interesting. I did not know the difference between expungement and sealing, and that's interesting to know. For the way USCIS and Department of Homeland Security, I mean, we're talking about the department that investigates terrorists. So they have very, very long hands, and um, they don't care if your case is expunged or sealed, or for them, they want to know the entire story, regardless. And so before an expungement, we usually especially ask that people get certified court dispositions, because
Yeah.
once their case is either sealed or expunged, then it's going to be near impossible for them to
Yeah,
obtain that.
exactly. Yep, that's true.
So a lot of times what happens is for expunged cases, when they run fingerprints in the, whether it's for a visa, port of entry or something like that, they're able to see the arrest record, but they're not able to see the rest of it. And so it flags it for them that there's something there. And that's enough for them to request more evidence to say, we've got to know the whole story. You've got to submit documents that show what happened or what the outcome was. And especially for expunged cases, it becomes very difficult for the client to find records.
Hmm.
Um, and sometimes we have at least the expungement paperwork, and sometimes we may not even have that. And so then, that makes it challenging for immigration cases, because usually they demand certified court dispositions
Okay.
um, for any kind of criminal arrest, conviction, any record at all that a person may have. But yeah, would how about juvenile cases? Are they usually sealed or
Yeah.
expunged or
All juvenile cases are technically automatically sealed because they're not open to the public.
got it?
But same rules, with juvenile cases, you even have more opportunities to get it expunged.
Got
There's the rules are more relaxed than expunging juvenile cases.
Okay, that's good to know. So um, so my takeaway from talking to you is there's so many layers of what could potentially happen as a result of an arrest, right?
Mhm.
With you as private counsel versus a client who's working with public defenders. Like, do you feel like there's a difference in the kinds of deals they may get or outcomes they may get?
Um, I really don't think so, and I'm actually also a contract public defender, so
Sure.
I'm
Okay.
both. I'm mainly a private attorney, but I do some contractual work with public defender offices,
Hmm.
and I think there's no real difference on the type of deals worked out. There is there's a horrible misconception that public defenders are public pretenders and they're not real attorneys.
Hmm.
But
Hmm.
public defenders, man, I'm telling you, they're the ones that are in court all day. They're the ones
They're
that are
super
doing,
experienced.
yeah, 12, 15, 20 jury trials in a year. They're the ones that are working fast paced and have to think on their feet.
Hmm.
And they are the ones that are usually reading most on current case law and changes in statutes and things of that nature. So um, our um, our chief public defender is great. She's wonderful. She always keeps us updated on changes in um, case changes in case law and forms that are coming out that we should be using and things like that.
Hmm.
So I feel like for me being a private attorney, also being a part-time public defender is great because I get to use the public defender resources as well. But there, I mean, I personally haven't seen anyone having horrible outcomes just because of a public defender. They're, like I said, they're rock stars. I'm telling you, all the trials they do, all the people they have to work
They
with
know the
and be
judges
prepared for
very
court.
well.
Yeah, yeah, they're
Right.
familiar with the judges, and surely they do the most jury trials than the private
Their
attorneys do.
function. Yeah.
Um, I when I was an assistant state's attorney, I obviously did jury trials, and then I joined private practice, and I haven't done nearly as much as I have when
Mm,
I was working for the county.
right. So, but would you say that at least as far as how much time you spend per client,
Yeah,
that makes you
so
have a little more time available to
yeah,
your
so public defenders don't have as much time as private attorneys, and that's just due to their caseload.
sure.
I I I spend my time more with my clients because I don't have the full on heavy caseload that a public defender's office might have. Sometimes they'll schedule a specific time, like, hey, court's at 10:30. If you're assigned my case, come at 9 o'clock, and then it's an assembly line, and this is like one by one. They're meeting with clients.
Right. And I think what you said is very valuable because when you said, that public defenders, they're just thrown into so much experience in so many cases, that, doing that on the side really builds your knowledge base and your experience level in a way. And you get to kind of have the best of both worlds where you can in private practice spend a little more time per client, but at the same time you have that background of having the resources and having worked as a public defender, assistant state's attorney, and in the public system too, right?
Yeah, I think that's and I'm not saying that this is the only way to do it, but I think it definitely helped me working for the state's attorney's office first, having that larger caseload, always being in court, doing all these hearings. Obviously, at the time, it's very stressful. It can be frustrating when you have a large caseload, but you get a lot of experience, and then you can say adios, go to private practice, have a little bit of a slower pace. But then, like what you said, you go in with all the knowledge you learned from your old job.
And what counties do you work in with that?
So my office is in Decatur, which is Macon County. That's
Hmm.
where most of my cases are. But I
Hmm.
also will take cases in DeWitt County, Piatt County, Moultrie County, um, and Logan County, along with Christian County, and Shelby County. So I'll take cases in the sixth and the fourth judicial district.
Got it. Got it. And so, in your districts that where you practice, what are some things that you would say, you wish that people would know? Like you wish that clients coming to you would know
Mhm.
these things.
So I I wish that they would understand that there is just a huge difference within the counties in within the specific circuit.
Hmm.
Like in Macon County, there is a large caseload, which is makes sense. The population is much higher,
Right.
so everything goes at lightning speed in court because there's
Hmm.
30, 40, people there, and it may take a while to get the case to trial because there's so many cases there lingering on. Whereas in a smaller county, such as um, DeWitt or even Pyatt, the judges have a little bit more time per case. Things go at a slower pace. It generally is easier to schedule things more faster because it's a smaller county as well. Um, and the only other thing that I wish they knew was that they need to stop posting things online about their
Yeah.
case because again, even though Macon County is larger than some of the other counties, it
Hmm.
still feels like everybody knows everyone, right? So
Hmm.
I always tell people to please be quiet, don't talk about your case. Nothing good will come up of it. If you want to
Right.
talk about your case, talk to me. And I always warn them that if they start talking to other people about their case, then they potentially just made more witnesses.
Yes, exactly.
Yeah.
And that's so important even for immigration law because, as I said, like admission is equal to conviction in immigration law. So they treat it just the same. So just having something online, it they treat it the same way. And it sometimes results in some really interesting and bizarre, situations. I unfortunately had a client. We fought hard to get him his green card, and he was, scheduled for his final interview. And right before his final interview, they have to do like a medical exam. um, and he partied before the medical exam, and so there were traces found, and then he admitted to it. So
No.
double whammy right there, you know. And it was 3 years of hard work. We had to restart everything because now we needed to file new waivers and new, everything for him. um so it was very unfortunate, that this happened, because obviously when someone is removed or deported, their entire family suffers, right?
Right.
So
Hmm.
it's devastating. It's devastating.
Yeah. I've had one client snatched right in front of me, and the authorities showed up to the courthouse and took him, and he started getting a little bit aggressive, and I had to tell him to just, this isn't going to help your situation. There's nothing I can do right now. The best thing you
Hmm.
can do is just be as calm as you can, because you don't want to have even more charges if you start hitting the immigration officers. And I there was two of them, and one of them thanked me for calming down my client. And I also asked them, hey, if you don't mind, is he able to call me um, while you're on the road to wherever you're taking him? And he's like, yeah. So they're very at least understanding of that. And my client then went ahead and called me while they were transporting him, and he was like, go ahead and call my wife, let her know what happened.
Of course.
And yeah, so I at least learned that I was doing the smart thing and always getting clients information on their spouse's phone number and name, or their parents number and name, just as some sort of emergency contact. And it was horrible. He had two small kids, one with a very serious medical condition, and I had to tell his wife the horrible news, and she wanted my help, and I couldn't help her. I don't practice immigration law, but I gave
Hmm.
her the names and numbers of some attorneys that she can call to see, if they can help.
Hmm. Yeah, and that's the other difference, I think, between your practice area and mine. is that you work specifically within certain counties, because your area of law and your area of practice, the location is very important. For me, I have clients in all 50 states. I have clients on the West Coast, East Coast, Illinois, everywhere. Um, Immigration law, there are some differences in when it comes to, the court system, but at least when it comes to applications, and so on, it's not dependent on where a person is located, really. So we just practice, from wherever the client is located. We work with criminal defense lawyers from time to time from all 50 states. And each state will have their own quirks and different potential solutions and so on. But with the way immigration law treats it, a lot of times we have to modify and twist how the case is presented so that the person doesn't suffer way way more than what they've actually you know done, so that the punishment fits the crime, in other words.
Have you I know we've discussed this before, that we are of the same ethnicity in India, and we're both polyglots. We know multiple languages.
Yeah.
And I know that there are amazing practitioners out there that don't know multiple languages, but I find it so easy to be able to talk to clients in their native language. I've had
Yes.
clients that um, speak languages that I don't know myself, and we've had to use an interpreter, which I'm happy we have so many good resources now for interpreters. You can get one online if you need one, right? Use Google if you have to, but being able to just talk to the client directly is so wonderful. And
Yeah.
I use different apps to make sure that I can improve my skills in Spanish. I'm not a native Spanish speaker by any means, but
Mhm.
I cannot stress how helpful it has been to be able to speak multiple languages.
Yeah, I agree. And like you, I speak multiple languages. I speak Hindi, Gujarati, Spanish
Yeah,
also, and I
same.
think you
Hmm.
do as well. Um, and these things are, also the other thing, other than the language, which I completely agree. I mean, being able to talk to a client in the language they're most comfortable in is invaluable. The way they open up is so different. Um, But the other thing that I find is that within the South Asian community, especially, there's a lot of stigma and shame associated with being arrested. Um, as an attorney, do you find that your clients are very reticent to come forward and seek help?
I found that they're willing to come forward and seek help. Usually they're very ashamed of what they've done, and they usually, if it's DUI related, then more often than not they do go ahead and start services immediately. I'm pretty assertive and pushy on that front, but ultimately I can't force them to get treatment, right? But I would
Yes,
say more often than not they're very ashamed of what happened, and usually they'll go ahead and start um, substance abuse treatment, or getting their DUI treatment done, or started, sorry, before they even plead guilty. Like they're just,
right.
you know,
And I think
they
it's
realize
so
they need help and
important
do
for
it.
people to know that as attorneys, we do not judge you. We've seen everything. We've
Yes.
seen everything you've had experienced and more. So, you know, don't be hesitant in front of a lawyer, at least.
Yeah.
Um,
I
you know,
had yeah, I had a there was a there's a Hindi speaking defendant once, and we got a pretty good deal worked out, but he was, in tears. He was crying,
mhm,
and he wasn't crying because he has to go to court and plead guilty. He's crying because he failed his wife. He failed
right.
his child. His
Right.
parents are upset with him,
Mhm,
and everybody in the Indian communities that I know that this guy was arrested.
right. I feel like the social punishment sometimes is the worst
It's the
kind.
worst, yeah, because everyone
Yeah.
knows what you did. Yeah.
Yeah. Yeah. But at least, I think it's helpful for people to know that when you are in front of a lawyer, you are in a safe space. You can be yourself. You can let go of any shame or guilt that you might be carrying with you, because we're here to help. And it's so important for you to seek help, especially for people who are hesitating to come to an immigration lawyer, um, or who don't even realize that maybe that might be important to do. It's so important to do that, and it's so important to not be shy in seeking help, because it's the only thing you can do for yourself that would actually be helpful.
Yeah, and I think the one thing that immigration attorneys and criminal defense attorneys and all attorneys, all of us have in common, the one rule that we all have in common is we all abide by attorney-client privilege.
Absolutely.
It doesn't matter what type of law you practice, there's attorney-client privilege, and you can speak freely to your attorney, and that confidentiality will be protected. I had
Exactly.
had a client tell me something the other day, and I can't share what it is, but it was something completely embarrassing.
Yeah.
Now, it wasn't completely relevant to the case, but I could understand why she thought it was relevant. It was completely embarrassing, humiliating what she told me,
Mhm.
and I told her, "Thank you for sharing, but this isn't gonna make or break the case." And she was like, "Oh," and I was like, "Are you okay?" And she's like,
Right.
"You're the only person I've told this to. I haven't told
Wow.
I haven't told my siblings this. I haven't told my parents this.
Hmm.
And I know I can tell you this because you can't tell anybody." I was like, "You're right. I cannot tell anyone." So,
Exactly.
yeah. So I do appreciate when clients take
Mhm.
advantage of the fact that we are here to help. We are here to help, and we're not going to share their secrets with the world.
Yeah, I'm going to put up your contact
Sure.
information, Nupa, and this is for everybody who is in the counties that you mentioned. You might want to repeat those again, to be able to contact you by phone or by email.
Sure. So, my office is located in Decatur, Macon County. I practice in Macon County, Piatt County, DeWitt County, Moultrie County, Logan County, Shelby County, and Christian County. Pretty much the heart of Illinois. I do criminal defense, but in addition to that, I also do family law, divorce cases, and I also do orders of protection and some DCFS appeals.
Okay,
And
great.
I just, oh, sorry.
Yeah,
I
go
just
ahead.
wanted to add that the firm I work at is a full service law firm. So we handle just a majority of the type of cases that be coming through. So we also do personal injury, wills, employment law, and estate planning as well.
Right. And what's your firm's web address so that I can send people there?
Yes, it is brelaw.com, BRELAW.com.
Right. So here's the web address for anybody that wants to hire this law firm. Um, they are wonderful, highly rated. I've worked with Nupa. She is an excellent lawyer, and she reached out to me, which already shows that she's very well aware of what, especially clients who are non-US citizens, and what they need. And I'm going to put up my information as well for anyone who is seeking immigration law advice or cases or whatever you may need. My phone number 312-854-7065 is for anyone anywhere in the world, really, because we are not limited by state law rules. So even though I'm licensed in Illinois and my office is in Chicago, we are able to practice law without regards to the state that our client is in. And my email address is right there. And my law firm, I'm going to put my law firm website also. It's there. It's oh, I put okay. That this here should be a colon, not a semicolon. But you got it. You swagatusa.com. Um, so if anybody is interested in contacting an immigration lawyer, and if you have been convicted, or if you're even looking at the possibility of a criminal charge arrest, anything like that, and you need to contact an immigration lawyer, then reach out to us. We do love it when people do that because then we can make the most difference rather than after the fact, after someone is already in removal proceedings or in facing, um, admissibility issues. Then we have limited scope in what we can do to help you. We can help you the most if you contact us early in the process. And I hope that everyone has found value out of this discussion here, and stay safe.
Right. Thank you for the invite.
Yeah.
Right.
Bye.
All right. Bye.